the City Council. The hearing shall be shall be not less than 10 nor more than 30 calendar days from the date such notice is received, except that in the case of the denial of a permit or card, if the applicant requests an earlier hearing, the City Council may hold the hearing earlier. It goes on to say that a notice shall enumerate the cause for withholding, suspending, or revoking the permit and shall be sent by certified mail, return receipt requested, to the applicant or holder of the permit at the address of his place or business as given in his application for the permit, or it may be served on him in person by an officer or employee of the city. In this case, in the case of a revocation or suspension of a permit, the notice shall subpoena the holder of the permit to appear and show cause why the permit should not be suspended or revoked. Today, approximately at 1 o'clock p.m., I was notified of a pending lawsuit that was filed on behalf of Hale State related specifically to this matter. It is an equal protection lawsuit filed in federal court. Additionally, I did make contact with Mr. Vegan regarding that issue as well as his intention for today. I know that there is legislation on the current agenda that this office anticipates will resolve potentially this matter. However, of course, we have not had given the time frame of the filing of this lawsuit, had an opportunity to discuss this matter further with City Council. It's my recommendation that we postpone this matter until the City Attorney's Office can make the City Council aware of the pending lawsuit and the implications of this hearing on that. We will be within the 10, not less than 10, nor more than 30 calendar days required under 10-133, and therefore can readdress this at the next available regular council meeting. I will request an executive session on the lawsuit filed by Pale State in order to bring you up to speed and also make recommendations moving forward. So my recommendation at this time is before we hear the merits of this matter, we postpone this until the next available meeting date.
Is there a motion to postpone?
Mr. Chairman, you might want to hear from the attorney for Pale State on this request for postponement.
Okay, I have a request to speak, if I may. First, Mr. Bradford, was Mr. Vegan provided a copy of the ordinance that is set for and that was introduced today?
Yes, I mean, it was made public to him as well as provided with him. I've had numerous conversations with Mr. Vegan regarding the ordinance as well as his intention to, or our intention to move forward with placing it on the agenda.
Okay.
May I speak on just the motion or the suggestion to postpone the hearing?
Yes.
First and foremost, Eric Vegan. I represent Pell State Oil Company and Pell State Bulk Plant LLC. We're bulk fuel distribution companies also in the oil field, but also we operate the C-store here. William's been very professional and has timely communicated with me. Thank you for that. I did also get to speak with Arthur Thompson, and he confirmed in writing that we do have this special hearing set for today. So before we even address the merits, which I think will take no more than 5 minutes on my side, I would like to go ahead and proceed. And I don't see any reason that we need to postpone the appeal for Pell State.
I mean, I'm going to ask if from our city attorney's perspective, is there any reason why we can't hear his 5-minute comment? This is in your legal capacity representing the city and the city council.
In my legal capacity, any statements made today potentially become evidentiary in the proceeding that has been filed by Pell State. It's the council's prerogative if they would like to hear, but it's my recommendation that we make no comments or have any interaction as far as discussion with Mr. Vegan related to the merits of this. But potentially, I think a postponement is the most appropriate measure until we can have an executive session on the matter and discuss the actual pending lawsuit.
Okay. But as far as hearing his comments, you're not, if we can keep our mouth shut afterwards, you're not opposed to that, are you?
No, I'm not opposed to hearing his comments on the record. No.
Okay.
Council.
I'll make that motion that we allow him to give his comments.
Well, I'm not gonna be able to not say nothing. I'm just.
It's called discipline.
No, well, I'm not having no discipline. I just,
Perhaps to help frame the issue a
well,
bit.
let me just say this, because I think we've done quite well as a council this term in terms of litigation. And being taking the advice of of the city attorney, and, not to throw any shade on any prior councils, but it's been pretty smooth the last 4 years. And I think that's largely because, we have a pretty good city attorney and staff who's worked very hard to represent the mayor's office and the council in a way that has not further damaged the city, and without naming any other, pending litigation matters. But I think following their lead has certainly not worsened the situation, as we've seen in some past litigation. So I'm just inclined, especially, I kind of glanced at it because we got an email, but I would rather them vet the lawsuit, do whatever research they have to do on it, and have all the information at one time. We have our information, and then he can provide his information, because that may change between now and the next hearing, because this litigation is pretty dynamic. And so we could get up-to-date information, current information, and have the benefit of them being able to vet everything. I'm probably definitely going to have some questions, and I don't want to be, I can keep my trap closed, but, I think on this one, it's going to be difficult for me. That's all I'm saying. And so I was trying to make a motion after he initially made his recommendation, and I guess if I need to make a substitute motion, or somebody needs to make one to say that, let's postpone the hearing.
Well,
That was the first, that was a question.
Well, there was a motion, but I don't know if it was a second. That's why I'm asking for a point of order. Where are we, in your opinion? Where are we in regard to?
That was a question. I made the motion, and I didn't get a second.
So, Mr. Chairman,
Did you make
Well, there was talk, there was some talk.
there was conversation, but I
Wasn't the
think
time.
after that was before the city attorney spoke, and I think the city attorney, in my opinion, was very clear on our options. I would make a motion at this time that this item would be postponed until
it would be the
recommendation of
27th, Mr.
27th?
Mr. Bradford, yes, sir.
until the 27th. That's my motion, Mr. Chairman.
I second.
Discussion.
Interrogative?
It's been moved by Councilman Bowman and moved by Councilman Bradford and seconded by the chair. Any
Question.
discussion?
Oh,
So in a public meeting, do we not have to provide for public comments? I'm just asking,
We don't in the,
special meeting.
but that's in
Work
an
session.
executive session.
That's in an executive session.
which is a
I
public
think
meeting.
we would have to
still.
provide for an opportunity for public comment.
Yeah,
Okay.
administrative comment.
Just trying to keep us in the right here. I'm not the lawyer. You're the lawyer on this. So we can vote down his motion to speak, but then he can request to speak under public comments. Is that?
We don't have a public comment section.
3
But
minutes.
yes,
For 3 minutes.
there's not a public comment section listed on this notice, but there should be, and there would be an opportunity for public comment.
Okay. I'm just trying to make sure that we're not getting ourselves in something.
Okay. That's fine, Mr. Chairman. I call for the question.
Mhm.
I call for the question.
If there's no other
Well,
discussion,
I just had one other thing to say, because certainly Mr. Vegan has the prerogative of talking with any council member about, the full details of whatever it is that you want us to know today. But, public comment is public comment, and he's afforded 3 minutes.
It's trying to- I'm gonna get us on a different one.
Yeah, no, it should have been on there.
please vote.
This is on Willie's motion.
Yes, ma'am.
To postpone, okay.
That motion carries 6-1 against.
Okay, so Mr. Chairman, can I be excused?
Yes, sir.
Yes.
Okay, I'm gonna say we're in the public comments. Is
That's
there anybody
next.
like to speak during the public comments section?
Yeah, thank you. Real quick, I mean, we're here on a pretty simple issue, and that's the denial by the ABO or the Shreveport Police of an application for the Chevron gas station on the corner of I-49 and Burt Coons, across from Home Depot, to sell wine. Essentially, there's really two issues that I'd like y'all to look at either now or in between now and the 27th, and that's the plain language of the statute. And that's, as a lawyer, that's what I look at. And the basis of the denial is 1084. And it's pretty clear, we can all read it. It says that, you know, you have to have a separate entrance to sell high content alcoholic beverages, except for wine, upon approval of the ZBA. And I've been told that, you know, the ZBA is kind of this outside process, but I think we look at what that statute means, and it says that if your zoning is correct, you can sell wine. And so that shouldn't come as some foreign idea for this body, because of the custom and practice of the city of Shreveport. And we've had some very, you know, straightforward discussions about other retailers in this city that have been allowed by custom practice and policy to sell wine without a separate entrance, and that's high content wine above 6%. And so that issue and how Pell State believes it's been treated differently is the subject of the suit that was filed yesterday. It's being handled by another attorney. The issue that I'm here for is ancillary to that, and that's just to go forward and get our high content permit to sell wine only. And so really, it's a very basic argument. It's that the Shreveport Police ABO's office has interpreted this ordinance incorrectly in light of our zoning by right in the UDC. I know you guys have spent a lot of time on the UDC. We have a P for beer and wine. We have an S for liquor, and liquor's not even in this equation. We're not allowed to do that. We don't want to sell liquor. We want to sell 13% wine, just like Brookshire's, Whole Foods, CVS, Rite Aid, a lot of other folks in the city do. So I think by looking at the plain language of the statute, looking at the custom policy and practice of the city, I think that statute needs to be interpreted in a way that allows us to get the permit to legally sell the wine. And I hope that all the other folks that are doing it now will also apply for the city, get their $500 high content permit as opposed to $150, pay more, get the permit and do it in compliance with the law. Whether or not y'all change 1084 is not really going to change our position with respect to the ordinance as it sits now. Our position at Pell State is that we, you know, by virtue of the P for wine on the UDC, that there, you know, a trip to the ZBA would be, you know, to interpret it to require us to go do something that we already have the permitted right to do is kind of an absurd result. Lawyers try not to read statutes in a way that lead to that. And so we'd ask that this body, I guess, I don't know if this meeting's over or not, but, you know, reverse the decision of the ABO Shreveport Police Department issue the permit. Thank you.
And just as a note, because litigation has been filed, we're going to request that communications also include the city attorney's office if you make any appeals to the city council as well.
Okay, well, I mean, we will need a decision from this body, you know, sitting above the ABO's office in its appellate capacity at some point.
Right.
So, thank you. Any questions?
This meeting's adjourned.
Thank you.
I guess I did.